Hello, Joshua. Thank you for joining us today.
Thanks, Danny. Really appreciate you having me on your show today. My first name is Joshua. My last name is SLAYEN. I'm the managing partner of a law firm in Vancouver called SLAYEN Immigration Law. We deal with things like, anything from emergency stays of removal. We're dealing with lots of challenging cases and
Wonderful. Yeah, that's intense. So you are covering the broader side of immigration, not doing the first initial applications, but the in depth, in detail, wherever clients are in trouble or whatever sort of problems they are facing, like the real ones. Even after refusal, I guess you step in and you look after them.
That's correct. Obviously, we deal with a lot of procedural fairness letters. We respond to them. We advise on them when it comes to these refusals and the consequences, like when there's an exclusion order in play and there's a couple that still wants to be together. So yeah, that work never seems to go away.
Of course, clean applications, I think we can field those ones.
I was going to say, so Emery does a lot of the refusal work, and I sort of work with him on the file as well. And then I do a lot of the mandamus work, which is something we can talk about later. But yeah, when there's a refusal, there's three things that people have to keep in mind. Number one, it's important to look at the reasons for the refusal and determine, is this something worth pursuing? Is this a refusal that was maybe non-favorable but fair or reasonable, which I'll get into? Or was this just a completely unfair, unreasonable, unacceptable refusal? We have to sort of evaluate it. The next thing is, if the refusal was unreasonable, then there should be an application for reconsideration that's submitted directly to IRCC. And I would also submit an application for leave and judicial review to the Federal Court of Canada, serve it on the Department of Justice, and await the Rule 9 reasons. The Rule 9 reasons detail, sometimes in more detail than even if there's this new notice of reasons, where they provide the reasons and or the refusal letter. A lot of times still we'll find that in the Rule 9 reasons, there's additional information that wasn't contained there beforehand. So it's prudent, if you think it might be unreasonable or unfair, to submit an application for leave to the federal court, at least to preserve your right of appeal until you review the Rule 9 reasons. Now, a lawyer that's representing a client in that case, they should be advising the client, is this decision unfair or unreasonable? Unfair means, hey, if there was a credibility concern, was it unreasonable whereby the officer didn't take all the evidence into account, properly rationalize their decision in accordance with the evidence? Once you receive the Rule 9 reasons with your lawyer and the lawyer determines that you have a case or don't have a case, if you don't have a case, you can withdraw the application. And if you do have a case, then you proceed forward.
No, that's wonderful. That's wonderful.